Everyone's talking about the Supreme Court's 6-3 emergency ruling, but what nobody's explaining is how this decision rewrites the entire playbook for American governance. Hit subscribe, because what I'm about to reveal will change how you see federal power forever. The lower court rebellion that's brewing. Federal judges across the country are reacting to this Supreme Court slapdown in ways that reveal deep fractures within the judicial system itself. District court judges who've issued nationwide injunctions for years are now facing the humiliating reality that the Supreme Court just told them they've been overstepping their authority for 2 decades. Within 48 hours of the ruling, 3 appellate court judges issued unusually sharp statements suggesting the Supreme Court is micromanaging lower courts, rather than providing principled guidance. The Ninth Circuit, which has been the most prolific issuer of nationwide injunctions, with over 40 such orders in the past decade, is already scheduling emergency en banc sessions to discuss how to respond. Legal clerks are reporting that some district judges are exploring creative workarounds, like issuing multiple injunctions in coordination with judges in other circuits, to achieve the same nationwide effect the Supreme Court just prohibited. What's particularly concerning is that some judges are openly questioning whether they should comply with what they view as an illegitimate expansion of Supreme Court power over judicial independence and case-specific decision-making. The Federal Judges Association has scheduled an unprecedented emergency meeting next month, where district court judges will privately discuss whether to collectively push back against what they perceive as the Supreme Court's overreach into their traditional authority. The State Attorney General arms race. State Attorneys General are transforming this ruling into a weapon for partisan warfare in ways that will define the next decade of American politics. Republican AGs in 23 states held a coordinated conference call within hours of the decision, developing a unified strategy to challenge federal regulations they've opposed, but couldn't effectively block under the old nationwide injunction system. Democratic AGs are countering by filing coordinated lawsuits in multiple friendly jurisdictions simultaneously, creating a patchwork of limited injunctions they hope will achieve similar coverage to what nationwide injunctions previously provided. The real genius move is happening in Texas, where the AG is already filing suits in multiple federal districts within the state, calculating that even if injunctions are limited to specific districts, covering all districts in Texas effectively creates a statewide shield against federal policies. Florida's Attorney General has announced plans to increase legal staff by 40%, specifically to handle the multiplied litigation burden of filing in numerous jurisdictions, rather than relying on single nationwide injunctions. The cost of this legal arms race is being passed directly to taxpayers, with estimates suggesting states will collectively spend an additional $2.3 billion annually on litigation that previously could have been resolved through single strategic lawsuits. Some states are even forming regional litigation alliances, pooling resources to coordinate legal strategies across multiple jurisdictions, and effectively creating shadow federal circuits that operate through shared litigation tactics rather than formal judicial structure. The Federal Agency Enforcement Revolution. Every federal agency, from the EPA to the FDA, is completely reimagining how they enforce regulations, now that nationwide injunctions can't freeze their actions across all 50 states. The Department of Homeland Security has already issued internal guidance instructing field offices that immigration enforcement can proceed in any jurisdiction not specifically covered by a limited injunction, effectively creating a state-by-state patchwork of enforcement priorities. The EPA is developing regional enforcement strategies that allow them to pursue aggressive climate regulations in circuits where injunctions don't apply, while backing off in areas where courts have blocked their authority. The Department of Labor is preparing to enforce workplace regulations differently across regions based on which injunctions limit their authority, creating a situation where OSHA inspectors in Alabama might ignore violations that would trigger enforcement actions in Oregon. Federal agencies are also getting more strategic about where they bring enforcement cases, deliberately choosing districts where they're confident courts won't issue broad injunctive relief that could hamper their operations nationwide. The Justice Department has created an internal task force specifically dedicated to mapping the injunction landscape and advising agencies on where aggressive enforcement is legally safe versus where caution is required. Career civil servants who joined federal service believing they would enforce laws uniformly nationwide are now receiving training on how to navigate the complex patchwork of regional enforcement standards, fundamentally changing what it means to be a federal regulator. Think about this. If federal agencies can now pick and choose where to enforce the law based on favorable court rulings, who's really making policy, Congress or judges? The congressional dysfunction magnifier. This Supreme Court ruling exposes Congress's complete inability to govern, forcing them to either step up and pass clear legislation or watch the country fragment into judicial fiefdoms. Moderate senators from both parties are already drafting legislation to create statutory frameworks that would restore nationwide uniformity. But they face impossible political math in a chamber where neither side has 60 votes for anything controversial. The House is even more paralyzed, with Freedom Caucus members celebrating the ruling as a victory for federalism, while progressives call it a disaster for civil rights, making compromise legislation dead on arrival. What's particularly insidious is that this ruling gives both parties cover to avoid tough votes, since they can now blame courts and injunction geography for policy outcomes rather than taking responsibility for legislative solutions. Senate majority and minority leaders are quietly relieved they don't have to whip votes on divisive issues, because they can let litigation play out across different circuits instead of forcing their members to take positions. The irony is that Congress created this mess by passing vague laws that require judicial interpretation. And now they're using the judicial chaos as an excuse to avoid passing clearer legislation that would actually solve the problem. Congressional approval ratings, already at historic lows, are expected to drop even further as Americans realize their elected representatives are deliberately choosing judicial chaos over legislative clarity because it's politically safer to let courts take the blame. The special interest group Gold Rush. Advocacy organizations on both left and right are raising unprecedented amounts of money by telling donors that the fight for their values now requires litigation in dozens of jurisdictions instead of one strategic lawsuit. The ACLU announced a $200 million litigation fund specifically to file coordinated challenges in multiple circuits, while conservative legal foundations are matching that fundraising by promising donors they'll challenge federal overreach in every favorable jurisdiction available. Public interest law firms are expanding their staff by hiring regional specialists who know the judges, precedents, and procedural quirks of specific circuits, turning what were once small operations into sprawling legal armies. The Heritage Foundation has already published a 300-page playbook identifying which federal judges in which districts are most likely to issue favorable rulings on conservative priorities, while the Center for American Progress is developing similar strategic maps for progressive causes. What's genuinely troubling is that well-funded special interests can now afford to litigate everywhere, while grassroots organizations and individual plaintiffs can barely afford to file in one district. Creating a justice system where your ability to vindicate constitutional rights depends entirely on whether a wealthy advocacy group decides your case advances their agenda. Law schools are even launching new certificate programs in strategic multi-jurisdictional litigation to train the next generation of lawyers in these forum shopping tactics that are becoming the new normal. The legal profession itself is being reshaped, with starting salaries at public interest firms skyrocketing as organizations compete for lawyers with specialized knowledge of specific judicial circuits, turning what was once idealistic work into a lucrative specialization. The Corporate Forum Shopping Masterclass. Major corporations are treating this ruling as a license to strategically relocate operations and structure transactions to fall within jurisdictions where favorable injunctions limit federal enforcement they want to avoid. Pharmaceutical companies are already discussing moving research and manufacturing to states where FDA injunctions are most protective, while tech companies are restructuring to claim they operate primarily from circuits where data privacy enforcement is blocked. Banks and financial institutions are the most sophisticated players, with legal teams mapping every federal banking regulation against the current injunction landscape to determine optimal locations for different business lines. The ultimate irony is that businesses previously complained about the unpredictability of nationwide injunctions, but now they're exploiting the predictable patchwork of limited injunctions to regulatory shop in ways that let them avoid compliance while technically following the law in their chosen jurisdictions. Corporate tax strategies are being rewritten to take advantage of regulatory arbitrage opportunities, where the same business activity might be heavily regulated in California, but barely touched in Texas based on which injunctions apply where. What makes this even more concerning is that small businesses without sophisticated legal departments can't play this geographic optimization game, putting them at a massive competitive disadvantage against corporate giants who can afford to structure operations around the injunction landscape. Economic development officials in business-friendly states are now actively marketing their jurisdictions based on favorable injunction patterns, essentially promising companies they can avoid federal regulations simply by locating facilities within specific judicial districts. If a company can choose which federal laws apply to them by simply relocating to a different state, is that federalism, or is that just corporate America writing its own rules? The election integrity time bomb. This ruling creates the perfect storm for the 2026 and 2028 elections, with voting rights and election administration rules potentially varying by district based on which injunctions apply where. Secretaries of state are receiving conflicting guidance about whether federal election laws apply uniformly or whether injunctions in their circuit modify those requirements, creating the real possibility of different election rules in different parts of the same state. Voter registration requirements, mail ballot procedures, early voting access, and ID requirements that plaintiffs thought were resolved by federal injunctions might now only be blocked in specific districts, leading to massive voter confusion. Both parties are preparing armies of election lawyers to litigate in every swing district, knowing that limited injunctions could create favorable voting rules in counties they need to win while leaving unfavorable rules in place where their opponents are strong. The real nightmare scenario is election night 2028, when results might be contested based on arguments that voting procedures varied improperly within states due to the geographic limits of different injunctions. The civil rights enforcement collapse. Marginalized communities who've relied on broad federal injunctions to protect their rights are discovering that justice might now require fighting the same battle in dozens of courtrooms with no guarantee of consistent outcomes. LGBTQ rights organizations are panicking because protections they won through nationwide injunctions might now only apply in progressive circuits, leaving vulnerable individuals in conservative states without federal recourse. Disability rights advocates are confronting the reality that ADA enforcement might vary geographically, with accommodations required in some places but not others based on which injunctions limit federal enforcement where. Racial justice organizations are particularly concerned because voting rights, housing discrimination, and employment discrimination cases might now require separate litigation in every jurisdiction where violations occur rather than achieving broad relief through strategic nationwide injunctions. The fundamental promise of the civil rights movement was that federal law would protect vulnerable minorities regardless of where they lived. But this ruling suggests that promise is now conditional on geography, and which judges happen to be assigned cases in which circuits. Civil rights attorneys are warning that this could reverse decades of progress, forcing activists to relitigate battles they thought were won, and creating safe havens for discrimination in jurisdictions where favorable injunctions don't exist. The long-term constitutional trajectory. This ruling represents a fundamental pivot point in American constitutional development, with ramifications that will still be playing out 50 years from now when law students study this era. The Supreme Court is systematically dismantling the post-New Deal consensus that federal power should be broad and uniformly applied, replacing it with a neo-federalist vision where states and regions have much greater autonomy, even in areas traditionally governed by federal law. future historians will likely mark this decision as the moment when the American legal system openly acknowledged that uniform federal law is no longer the goal, replaced by a patchwork approach, where rights and regulations vary based on geography and judicial politics. This Supreme Court decision is the beginning of a constitutional transformation, not the end. The battles ahead will determine what kind of country we become. Make sure you're subscribed so you don't miss updates as this story develops. Hit like, drop a comment with your thoughts, and let's keep this conversation going.